Lunchtime Politics on Channels Television. I'm Millicent Walker. On the news this hour, Islamic Movement of Nigeria, IMN, challenges Experte application by the federal government outlawing activities of the group in the country. The federal government dispels anxieties over possible loss of Nigeria's foreign asset as a result of the UK court judgment fine of $9.6 billion on a field gas project. And stakeholders in Nigeria's transition process go back to the drawing board to address knotty issues in Nigeria's election collation process. Welcome everyone to the program. We begin this afternoon with news of the Islamic Movement of Nigeria, IMN, at the Federal High Court in Abuja, seeking a vacation of an Experte order granted the federal government to prescribe its activities in the country. The IMN, in a motion filed on August the 2nd by its lawyer, Mr. Femi Falana, had sought the court to vacate the order made on July the 26th, outlawing the existence of the group. The court had, upon an ex parte motion by the Office of the Attorney General of the Federation, also declared the group a terrorist organization. The federal government had, on July the 29th, published the order in its official gazette as directed by court. But let's now get more updates from our correspondent Linda Kibe at the Federal High Court, Abuja. Hello, Linda. Has the court made a decision?
Hello, Millicent. Now, two suits came up this morning at the Federal High Court in Abuja. The first being the suit by members of Islamic Movement of Nigeria, IMN, challenging their prescription. And the second suit is the one filed by the convener of Revolution Now, Omoyele Sowore, challenging the ex parte order granted by Justice Taiwo, empowering the DSS to detain him for 45 days. Now, attempts by members of IMN to challenge their prescription by the federal government suffered a setback as Justice Evelyn Maha adjourned the suit to September the 11th, 2019. The adjournment is predicated on an application for extension of time filed by the council to the Department of State Services, DSS. Now, the DSS is asking the court for more time to enable them regularize a motion filed in respect of the suit. Now, as regards the application for expeditious hearing on the motion in the suit of Omoyele Sowore challenging Justice Taiwo's order, the court declined hearing the motion on the ground that it would amount to reviewing the order of a court of equal jurisdiction. And the court further says that the matter is before Justice Taiwo, who has fixed a date for the hearing. Now, we'll bring you more details of these two cases in subsequent news bulletins. Now, back to you, Millicent.
All right, many thanks, Linda Kibe, with the latest there. Well, still on legal matters, yesterday was indeed day two of the biggest gathering of the bar and the bench of the Nigerian Bar Association conference in Lagos. Now, at the Rule of Law Symposium of the NBA conference, the view of the Senate Minority Leader, Senator Ayinaya Baribe, was explicit on the suspension and eventual exit of the former Chief Justice of Nigeria, Justice Walter Onoge. Senator Baribe and other practitioners spoke on the topic, independence of the judiciary beyond letters of the law. Our judiciary correspondent, Shola Shuele, reports.
It's day two of the annual General Conference of the Nigerian Bar Association. And one of the interesting sessions here is the plenary session, titled Rule of Law Symposium,
very unfortunate,
which was chaired by former president of the Nigerian Bar Association, Olisa Agbakoba. One of the speakers here is the Senate Minority Leader, who had some tough questions for the lawyers.
In the matter of Onoge, what happened? We waited for the Bar Association, nothing happened. We waited for their fellow judges, nothing happened. And everybody was looking at us. And what we were waiting for, because the law is very clear, you cannot remove a Chief Justice without coming to the Senate. Yet, it happened, and nothing happened.
It has happened, and it's something that I hope we will use as a reference point about what we can do. That's the point the distinguished senator made. And I thank you very much for telling us the truth.
These comments sparked off a lot of reactions, including this robust exchange.
Is there anything wrong with lawyers since members of the bench are defunct and they cannot protest by themselves, taking on the kind of role we saw lawyers do on the 9th of March 2007 when they went to the streets in Pakistan and shut down the entire country because President Pervez Musharraf removed unjustly and unconstitutionally Mohammed Musharraf, the then Chief Justice. Can't we do more than we have done?
My learned friend talked about Pakistan. Yes, the Chief Justice then was not removed for corruption. Olisa, can the NBA morally go to the street to fight for judges who have millions that they cannot account for in their accounts?
Plenty of issues here for the lawyers to ponder on. The conference continues on Wednesday. Shola Shoyele, Channels Television News.
Lots to talk about there. But elsewhere, the federal government seems really worried about the London court verdict, which awarded $9 billion of Nigeria's assets to a private firm over a botched gas deal. Now, yesterday, the Minister of Information and Culture says the country is not about to lose any of its assets, despite the ruling, and his comments is being corroborated by the Attorney General of the Federation, who alleged that the contract was designed to fail as the processes involved were not adhered to. The central bank governor also made a damning revelation, insisting that the country has no record of the $40 million the Irish company said they had invested in the project. Our correspondent Kayla Migwa reports.
In January of 2010, under President Umar Musa Yar'Adua, Irish firm Process and Industrial Development Limited reached a gas supply and processing agreement with Nigeria's Ministry of Petroleum Resources. According to court documents, in the agreement, Nigeria was to supply natural gas at no cost to P&ID, while P&ID was required to construct and operate the facility in Calabar, process the natural gas, return it to the Nigerian government for power generation, also at zero cost for 20 years. The deal fell apart 2 years after, with P&ID suing the Nigerian government for reneging on their part of the agreement. After affirming its jurisdiction on the matter, an arbitration tribunal in England in 2017 awarded P&ID $6.6 billion. Fast forward to 2019, the interest on that amount is now $2.4 billion, bringing the total amount awarded to $9 billion to be paid in assets. Assets which the Nigerian government are determined not to let go of.
Nigeria is not, and I repeat, is not about to lose any of its assets to P&ID.
The Attorney General of the Federation is alarmed by the deal, alleging that the contract itself was designed to fail, questioning the characters behind the proposed deal.
When you conceived, sign and execute a contract for the supply of gas products without involving IOCs, NPDC, and NNPC as a party to that agreement, you know very well that there are a lot of questions to answer arising from the execution of that agreement.
The company, P&ID, alleges that it had invested $40 million into the project. The governor of the Central Bank of Nigeria says that claim is false.